If a buyer contracts to purchase goods from a seller, and the seller breaches by failing to deliver, then the buyer's usual remedy under the Uniform Commercial Code is monetary damages. But in some cases, specific performance may be available. If awarded, specific performance requires the seller to deliver the goods as contracted for. We explore when specific performance is available in CMA CGM SA versus Waterfront Container Leasing Company. In March of 2007, CMA CGM contracted to lease over 7,000 shipping containers from Waterfront Container Leasing Company for 5 years. The lease included a purchase option that allowed CMA to purchase all of the leased containers from Waterfront at the end of the lease period for a specified price. In January of 2012, as the lease's end neared, CMA sent Waterfront notice of intent to exercise the purchase option in compliance with the contract's notice requirement. Waterfront refused to honor the purchase option, and when the lease period ended, demanded return of the containers. CMA began returning containers, and as they were returned, Waterfront sold them to third parties. CMA had returned about half of the containers when it filed a breach of contract suit against Waterfront. Upon initial motions for summary judgment, the district court held that Waterfront breached by failing to honor the purchase option. The court also held that CMA was liable for per diem charges for its use of containers beyond the lease period. The parties' focus turned to remedies. Among other things, CMA argued that specific performance was appropriate as to the 3,000-plus containers still in its possession, asking the court to order Waterfront to honor the purchase option as to those containers. Waterfront argued that specific performance wasn't appropriate because CMA could cover, meaning it could purchase replacement containers elsewhere, making monetary damages adequate. Both parties moved for summary judgment in the district court.